crime statistics in Malaysia presents 5 selected statistics, which is crime index, commercial crime, corruption, drugs, and correctional facilities. Those crimes were present in 4 years from 2019, 2020, 2021, and 2022. Firstly, there are 2 types of crime index, which is violence and property crimes. Violent crimes include robbery with firearms and without firearms, gang robbery with firearms and without it, causing injury, rape that involves Section 376 of Penal Code, and murder. While property crimes include house breaking and theft, vehicle theft, snatch theft, and other theft. In 2019, there are 16,489 violence cases and 66,967 cases for property crimes and have 83,456 total of cases. However, in 2020, those cases were decreased by 21.4% to 65,623 cases, where 30,279 cases were from violence crimes and 52,344 cases were from property crimes. Continued to 2021, crime index also decreased to 52,974 cases by 19.3%. Violent cases decreased by 13.4% to 11,495 cases, and property crimes by 20.8% to 41,479 cases. Also in 2022, violence and property crimes were decreased with each 10% and 2.4%. Despite of the reduction, there are also expansion in rape cases and vehicle theft from 1,553 and 13,432 cases in 2021 to 1,712 and 14,446 cases in 2022.
Based on the table, we can see that the number of drug addicts is initially decreasing from 2019 to 2021. Then there is a rise in incidence in 2022. The number also compared by age groups, with the majority of drug users aged 30 to 40 years and older. Furthermore, in the educational sphere, the bulk of people participating in drug activities are from secondary school. If according to gender, men are more dominating than women, and meanwhile, the type of the drug preferred by the majority of drug addicts is methamphetamine crystalline. Following that, the movement control order during the COVID-19 pandemic played a role for the drop and increase in the drug cases.
Next is corruption. According to the Malaysian Anti-Corruption Commission, investigate reports state that Malaysian corruption cases are likewise growing increasingly concerning years. Based on investigation paper, the total cases in 2019 was 1039 cases, but it was a rise for 1101 cases. In 2020, the number of investigation papers were decreased by 70.5%, and for the arrests also decreased for 9.4 cases. For the 2021, the cases recorded a decrease by 1.0% to 820 cases. Furthermore, in 2022, presentation recorded was 6.8%, with the total of 851 cases, and for the arrest is 909 cases. The corruption case included accepting bribery, giving bribery, false claim, misposition, and other offences. If we look further, cases including giving bribery and accepting bribery are always increased from year to year. But fortunately, other offences is reported always seems decreased, which made the number of cases also stable in a many way. Now, we look at the commercial crime. The Department of Statistics Malaysia showed that there were 323 cases in total in 2020. Meanwhile, in 2021, it was reported an increase, which the total number of cases is 3,536 cases. Furthermore, for the 2022, the cases is total 31,497 cases. Cases caused of commercial crime are fraud, breach of trust, money lending, cyber crimes, counterfeit money, forgery, property misses, other cases, and VCD or DVD without certificate. Every year, fraud is contributed as one of the biggest cases that cause the statistic to be increased. Nevertheless, cases of both VOD or DVD without a certificate is always decreased from years and become the least cases from the others.
Next, we move to correctional facilities. As you can see in the table in 2019 and 2020, there are no statistics according to correctional facilities that have been released by the Department of Statistics Malaysia. However, in 2022, the number of prisoners and parolies increased compared to 2021. According to the gender, the number of male convicts declined in 2022, while the number of female prisoners was increased. Overall, we can see that men more outnumber than women in the present population. In conclusion, Department of Statistics Malaysia indicates that a variety of causes contribute to the majority of the country's annual increase in criminal cases. As a result, all parties must play their respective role in order to limit the increase of crime in Malaysia. This has been the potential to make Malaysia a safer country with less crime cases.
There are two categories of offences under Malaysian Penal Code. First is offences against person and second is offences against property. For offences against person, there are several types of offences. Firstly, homicide under Section 299 to Section 304 of Penal Code. It covers a wide range of illegal cases such as murder, culpable homicide that is not murder, and negligence related to death. One famous case that established the manslaughter of recklessness in English law is R. N. Cunningham. Murder, on the other hand, is defined as an act committed with the knowledge or purpose of inflicting death under Section 300. Murder cases also bear the relevance of the well-known case of R. N. Cunningham, which established the standard for carelessness. Furthermore, the notion of constructive murder, as expounded in the R. N. Cunningham case, expands the extent of charge related to murder. This offence can be seen in the situation such as two friends, A and B, agree angrily about a bush business deal. As their disagreement gets more heated, A loses his control and smacks B across the head with a blunt item that is close by. B suffered several head injuries and is unconscious and is eventually declared died in the hospital. A's conduct could be regarded as responsible homicide in this case. Secondly, assault under Section 351 to Section 358 of Penal Code. This section addresses different types of violence and injury. Whereas hurt refers to inflicting physical pain or injury, assault is the deliberate threat or use of force. The punishment is determined by the seriousness of the offence, taking into account elements such as the use of weapons and the degree of damage caused. Assault can be seen in the case of R and Ireland, which holds that silence may constitute an assault. In this instance, the defendant called the victim repeatedly without saying anything, instilling them a dread of employing force right away and suffering them great psychological harm as a result of his persistent calls. Also, these offences can be seen in the situations such as an dispute over a parking spot resulted in one man pushing the other to the floor. The man on the ground had a broken wrist in addition to an abrasion. The person who shoved him was subsequently taken into custody for assault. Next is kidnapping and abduction under Section 359 to Section 374 of Penal Code. This section deals with crimes involving kidnapping and abduction. These offences entail the forcible incarceration of an individual against their will. The code makes a distinction between abduction with the intention of forcing marriage, unjust imprisonment, and kidnapping for ransom. In the case of Nuraini Mat Zainul SPP, a magistrate court in Sungai Petani convicted Nuraini Mat Zainul guilty for kidnapping the baby from Sungai Petani Hospital. According to the ruling, the prosecution had established a prima facie case against Nuraini in this case, and the lower court ought to have recognised the secretary's testimony that Nuraini was not acting in her normal state of mind when she committed the crime. Accepting the secretary's expert's testimony, the High Court directs that Nuraini be taken to Hospital Bahagia in Ulu Kinta, Perak. Furthermore, Muhammad Sabdi Sabidin, Nuraini's ex-husband, was given a 3 years prison sentence for his role in the baby's kidnapping. The situation that can describe these offences is A kidnaps B from Malaysia with the knowledge or purpose of knowing that B might be offered as an idol. A has engaged in the activities specified in this clause. For offences against property, there are theft, robbery and burglary. For theft, it's stated under Section 378 to Section 382 under Penal Code. The dishonest taking of movable property with the intention of permanently depriving the owner is called theft.
The degree of punishment varies depending on the value of the stolen property and the method of theft. And this can be seen in the case of PP and Ramya. The three defendants in this instance were charged with burglary and theft after taking the victim's trunk. A few days later, one of the accused was found in possession of the trunk containing the contents. According to the accused, the victim owed him money and the trunk was taken out to provide security so the victim could settle the obligation. The court then found them guilty of larceny. The theft can be seen in the situations such as being Meme's servant and having been given Meme's plate to look after. Siti dishonestly takes the plate and leaves without Meme's permission. Siti has committed theft. For robbery is stated under Section 383 to Section 389 of Penal Code. Robbery is theft committed with the threat or actual use of force. The code makes a distinction between armed and simple robbery, with the latter carrying harsher punishment. The use of violence and the presence of weapon determine the seriousness of the act. This offence can be seen in the case of Anand anak lelaki Govindaraji and other individuals raya pendakwa. In front of his home, the respondent was robbed by the appellant. The appellant grabbed him against his will, forced him into his own car and battered him until he was taken to an unidentified location. The appellant then freed the respondent but not before seizing his credit card, car and cell phone. The court held and declared that theft or extortion is robbery when it is motivated by violence or creates fear of harm, death, or improper restraint. The situation that robbery can be seen is, for example, B is strolling beside a road, B is injured when A riding a motorbike steals her handbag, and A takes off riding with B's purse. Thus, A has committed robbery. Lastly is burglary that's stated under Section 441 to Section 449. Unauthorized entry into structure or piece of property with the intention of committing a crime, typically theft, is known as burglary. Referring to the case of R and Ryan, the defendant was discovered by the victim, an elderly resident, lodged in a downstairs window of his home. The window had fallen on the defendant's neck, trapping him with his head and right arm inside. Outside the window was the remainder of his body. After being found guilty of burglary, he filed an appeal, arguing that he was stranded and could not have taken anything from inside the premise. These offences also can be seen in the situations such as Abu enters Ali's home via the door, trespassing after using a wire to push a latch open through the opening.
Next, I am going to be telling you guys about defenses stated in the Penal Code. So the first defense is mistake. Mistake has been mentioned in section 76 and 79. There are two forms of mistake. The first one is mistake of fact. The second one is mistake by law. So section 76 of the Penal Code stated that nothing is illegal if someone does it because they honestly believe they are required to by law, even if they are wrong about the facts and not the law. While section 79 stated that nothing is illegal if someone is allowed to do it by the law, or if they mistakenly believe that they are allowed to do it by the law, even if they know that they are wrong. The case related with mistake is Sulong bin Nain versus public prosecutor. The charged person was caught with 2 hand grenades on him. The accused then used mistake as a defense because he honestly thought that the law required him to hand over the bomb to the police. The court turned down his case because it noticed that the act was a mistake of law and not a mistake of fact. Another situation that could happen is a court officer, A, was told by the court to arrest Y, and after doing some research, he or she thought that Z was Y. A has not done anything wrong. The next defense is accident. The Penal Code defined accident in section 80 as nothing is illegal if it is done by accident or bad luck, and the person doing it didn't mean to do something illegal as long as they did it legally, with care and with the right amount of caution. So in order to use this defense successfully, you must have these 4 elements. The first one is the claimed crime happened because of an accident or bad luck. Next, the thing that caused the accident wasn't done on purpose or with knowledge of breaking the law. The third one is the act was legal and was done in a legal way. And the last one is the act was done with the right amount of care and caution. In the case of public prosecutor versus Andal bin Arola, the accused had attacked the deceased. It was testified that the accused had planned to murder the deceased after the drug transaction by using a Rambo knife. It was also said that the suspect stabbed the victim in the chest and at the neck. The stab wound in the neck was what killed the person, according to the autopsy. The accused defense said that the injury to the victim's neck was a mistake because he did not mean to stab the victim and the knife went through the victim's neck when the car moved forward. The court ruled that Section 80 of the Penal Code did not apply since the accused murdered the individual on purpose and cut them. Thus, the individual who died was murdered illegally. Next defense is duress. According to Section 94 of the Penal Code, it defined duress as except for murder and crimes listed in Chapter 6 that are punished by death, nothing will be considered as an offense if the person doing it is forced to do it by threats that make them fairly fear that they will die right then and there. One who is being threatened with harm to themselves or their family is said to have done something illegal, which means they did not do it voluntarily. This is called duress. The defense of duress is allowed because people make mistakes when they have to decide between causing harm or breaking the law. There isn't much of a choice in that case. The legal maxim means that I am not responsible for something I did against my will because it wasn't my choice. There were a few conditions in order to use duress as a defense, which are the threat must be death. The second one, the threat can cause an instant death. The third one, the threat must be objective in character. The next one, the threat must be directed at the accused himself. And the last one, the accused can't be voluntarily exposed to threats. There is also a limitation to the defense of duress under Section 94. For crimes against the state that are punished by death, the part says that force is not a defense to a charge under it, but depending on the details of a case, it may lessen the sentence. In the case of public prosecutor versus Muhammad Amin Muhammad Razali and Ors, according to the facts, the 29 people who were charged under Section 121 of the Penal Code with making war against the Yang di-Pertuan Agong. Warring against the Yang di-Pertuan Agong is a crime under Section 121 of our Penal Code. It is a crime against the state under Chapter 6 of the Penal Code and is punished by death. So, in this case, the accused threat or pressure is not a defense to the charge they are facing. Lastly, the next defense is consent. The Penal Code doesn't define the word consent. However, according to Ratan Lal and Diraj Lal Law of Crimes, consent means an act of reason, accompanied with deliberation, as in a balance the good and evil on each side. According to Section 87 in the Penal Code, a person who does something that isn't meant to kill or seriously hurt someone and doesn't know it's likely to do so is illegal because it hurts someone over 18 or knows it's likely to hurt someone who has given their express or implied permission to be hurt. This portion is based on he who consents shall not be hurt. There are three elements of consent which are death or grievous harm aren't planned. Unknown to the perpetrator, it may result in death or terrible harm, and consenting parties must be above 18 years old. In the case of Bishamba versus Rumal, the complainant abused a girl. Instead of being beaten, he had his face and shoe blackened. Complainant consented in writing for personal gain. Another example of a situation is A and Z fences for fun. This arrangement indicates both parties will accept any fencing-related injury without fault. Playing appropriately, A may damage Z without breaching the law.